Well, brothers and sisters, it's great to be with you. Thank you for tuning in to this presentation regarding religious freedom. My name is Alexander Dushku. I'm an attorney in Salt Lake City in private practice, and much of my practice relates to religious freedom, especially as pertains to religious organizations like churches. This topic of religious freedom is extraordinarily important, and you know it is. You've heard members of the Quorum of the 12 Apostles and members of the First Presidency talk about this now for a number of years. I was trying to make a list a little bit earlier about the different apostles who have spoken on this, and by my count, it's President Oaks, Elder Bednar, Elder Cook, Elder Christofferson, Elder Rasband, Elder Stevenson, and there may be others who have spoken about this absolutely vital issue. So thank you for being interested. I think every time they have spoken about this issue, they have emphasized the importance of getting informed, of understanding more about why religious freedom is important and about some of the challenges that religious freedom faces. And I know that's why you're here today, and I just want to say thank you, each one of you, for your willingness to learn a little bit more and ultimately to get involved in defending religious freedom. Now, the topic of religious freedom is very big, and we have a little less than an hour today. If we had 10 hours, we couldn't get to the bottom of this. But I'm going to try to go through some topics that I think will be useful. I've kind of focused my presentation on what the Supreme Court is up to and what, in fact, might be coming through the Supreme Court and with the Supreme Court. We could talk about a lot of other things. We could talk about the Founding Fathers. We could talk about the history of religious freedom. We could talk about times when the United States has really failed to protect religious freedom. But I thought it'd be useful to talk about religious freedom through the lens of the Supreme Court. Let me just give you a little bit of an outline as to what we're going to go through. First, we're going to talk about what is religious freedom, both for individuals and for institutions. It's really important that when we're talking about religious freedom that we have an understanding of the term. What exactly does it mean when we say religious freedom? And that'll get us into the topic. Second, I'm going to talk briefly about the First Amendment to the United States Constitution and the role of the courts in interpreting the Constitution, and then how that relates to religious freedom. And then we'll spend the bulk of our time talking about how the Supreme Court addresses religious freedom cases. We're going to go back and take a look at a few cases from the past and a number of cases that just came down just within the last couple of months. And then we'll talk briefly about some issues that are on the horizon, and then I'll offer some concluding thoughts. Now, defining religious freedom. There are lots of discussions about religious freedom, and a lot of times people talk about religious freedom in ways that are conflicting because they actually begin with definitions that are radically opposed to each other. Very different conceptions of religious freedom lead to very different outcomes and results. I'd like to direct you to a website that the church has, religiousfreedom.lds.org. We're not using the LDS term very much anymore. This is a little bit older website link to it, but it's still very current in terms of its content, and it's a way to find a lot of great resources. religiousfreedom.lds.org. Look it up, and there you will find a definition of religious freedom that's been approved by the Brethren. And I wanted to start here because I think what the Brethren have set forth is deeply insightful, and I think it's very helpful as we begin to talk and to think about religious freedom. Now, I don't want to suggest that this is a comprehensive definition of religious freedom. It's not. It doesn't claim to be. I also am not going to be able to read all of it, so I'd encourage you to take a look at it. But it's a great place to start. Let's read it briefly. Freedom of religion is a basic principle of the Church of Jesus Christ of Latter-day Saints and a fundamental human right. Moral agency, the ability to choose right from wrong and to act for ourselves, is essential to God's plan of salvation. Religious freedom ensures that people can exercise their agency in matters of faith. Now, that is the doctrinal framework for then a number of practical things that follow. The statement goes on, religious freedom safeguards the right of all people to hold their own religious beliefs and express them openly without fear of persecution or being denied equal rights of citizenship. The statement continues, it ensures, speaking of religious freedom, it ensures that people can freely choose or change their religion, teach their faith to their children, receive and disseminate religious information, gather with others to worship, and participate in the ceremonies and practices of their faith. It protects individuals from religious discrimination in employment, housing, and other basic services, and prevents people from being denied the right to have a business, occupation, or professional license based on their religion. Now, the statement goes on to explain a number of other things, and then it has this important statement that I think is important for all of us to remember. Religious freedom is not absolute. Limits on religious activities are appropriate where necessary to protect compelling interests, such as the life, property, health, or safety of others. Where the law constrains religious freedom, Latter-day Saints believe in obeying the law while seeking protection for their fundamental rights through such lawful means as may be available in each jurisdiction or country. In other words, we don't riot because our religious freedom is not being perfectly protected. We seek to use the courts, we seek to use the democratic institutions that exist in order to get things changed to the extent they need to be changed. So let's talk about religious freedom. And I've added an S to the word, religious freedoms, because there are many different facets, many different aspects of religious freedom. There is the religious freedom of individuals, and then we'll talk in a minute about the religious freedom of institutions like churches and religious schools and religious charities and so forth. But let's start with individuals. You have a right to believe, at the very heart of religious freedom is the right to believe anything you want about God and to express those beliefs openly without fear of persecution or being denied the equal rights of citizenship. So the right to believe something and to express it, that's right at the very core of what we mean when we say religious freedom. You have a right to choose your religion or to choose to no longer follow a religion. That's part of religious freedom. You have a right to choose a church. The church doesn't have to take you, but you have the right to choose a church and belong to any church you like. You have a right to start your own church. You have a right to teach your faith to your children. Think how important that is, that we be able to pass on our faith to our children. You also have a right to gather with others to worship and participate in the ceremonies and practices of your faith. These things are absolutely essential to true religious freedom. Let's talk about some other things. In a modern society, religious freedom includes a right not to be discriminated against in employment, housing, and other basic services on the basis of religion. And also no denial of the right to have a business or occupation based on your religion. So it shouldn't be the case that if you go down to open up a business and you go down to the government office to establish a corporation, it shouldn't be the case that they say, well, what is your faith? And you say, well, I'm a member of the Church of Jesus Christ of Latter-day Saints. And they say, oh, well, sorry, we don't grant to Latter-day Saints business licenses. Now that, of course, would be a serious violation of religious freedom. That kind of thing, of course, always happened in times past to Jews living in Europe. They were prohibited from engaging in certain kinds of businesses, just completely excluded. That, of course, is a gross violation of religious freedom. You have the right to freely worship and speak and act based on your religious beliefs. In other words, to exercise your religion in your life, not only within your home or within the church. You have a right to run your business according to your religious beliefs and values. Now, these last two that I've mentioned, these last two bullet points, they are not, in the nature of things, absolute. We'll talk about that a little bit more later. So while we do indeed have the right to speak and act based on our religious beliefs, and that right needs to be strong, no question about that, it's also the case that it can't be taken to an absurd conclusion. So for example, if you are an Aztec priest and you have found someone who is willing to let you perform a human sacrifice on him, you don't have that right in the United States of America. You don't have that right under any real conception of religious freedom to engage in human sacrifice or in anything else that might seriously harm another person. That's not part of the right. So the right needs to be robust, but of course it can't be absolute. In the business context, business is highly regulated. It's regulated in all kinds of ways, with environmental regulations and labor regulations, tax, and so forth. We have many rights in the business context to exercise our religion, but we don't have absolute rights to exercise our religion. So those are a number of rights of individual believers. Let's take a look at rights of religious organizations, the freedom of religious organizations and churches. So the right to form churches and other religious institutions, such as religious schools and charities. That's absolutely vital, the ability to form an organization. You think about the establishment of the Church of Jesus Christ of Latter-day Saints in 1830. That was done because the law in New York allowed for that to occur, and that is a fundamental freedom that's just vital. Churches and religious institutions, they also need to have the freedom to establish their own doctrines, to establish their own ways of worship. So imagine if the government could come in and say, well, you can't believe this, and you can't practice that. You can't believe in living prophets and apostles. And by the way, you can't perform the sacrament on Sunday in this particular way. You have to perform it in that way. You have to use wine. You can't use water. Imagine if the government said that. That would be a serious violation of vitally important religious freedoms. Churches have to be able to organize their ecclesiastical affairs. In other words, to determine whether they're going to make decisions through a first presidency and a quorum of the 12 or through a pope, or whether they're going to make all their decisions through an assembly, through a democratic process. There are lots of different forms of churches. How it is that they're going to get together on Sundays, how often they're going to get together. All of these are ecclesiastical affairs, and they are absolutely vital to the health and the well-being of a religious organization, and the government has no business interfering with that in the vast majority of cases. Related, religious organizations, churches have to have the ability to determine requirements for membership. Who can be a member? What do you have to do to become a member? You have to be baptized. How do you get baptized if you're going to have baptism as a criteria for becoming a member? For ecclesiastical office, who is it who qualifies to be a bishop or a stake president or an apostle or a priest or a Relief Society president? Whatever the case may be, churches have to be able to control that. And they need to be able also to determine who works for them, to have religious standards and criteria to ensure that only those who truly support the faith work for the church itself. So you think about church headquarters, for example, and the ability to have a temple recommend standard at church headquarters so that only those who truly believe in the church and are willing to support its goals are there within church headquarters working to advance the goals of the church. Churches have to be able to own property and construct places of worship and to be able to control that property. Think about the ability to build chapels and meeting houses and temples. Okay? Now, as I mentioned earlier, there are limits on religious freedom. Religious freedom is not absolute. I mentioned the Aztec priest just as a kind of fanciful example. There are other examples. You don't have a right to harm other people, to impose physical harm, for example, on other people, or to hurt someone else's property. just because that happens to be part of your religion. So limits on religious activities are appropriate where necessary to protect life, property, health, and safety, or to prevent real harm to others. That's an important limitation. It's one that we all recognize. The fact that our neighbor's religion requires them to come over and punch us in the mouth, if that were the case, we would not say that that's part of religious freedom for obvious reasons. Something else that sometimes I think is a little confusing. We live in a diverse democratic society, and religious people, sometimes the things that they believe ought to occur are reflected in public policy, and sometimes they're not. And just because our personal policy preferences are not always reflected in government policy, in the law, that doesn't mean that our religious freedom has been suppressed and that we have an absolute right to kind of opt out of what the government's doing. We live in a democratic society. We have been taught, it's one of our articles of faith, that we obey, honor, and sustain the law. And so we don't have a religious freedom right to just opt out of everything that the government may require of us. We have, rather, a right to participate in the democratic process. Now, of course, there are situations where government goes too far and when truly it does infringe upon vitally important religious rights. And in those instances, we have courts and legislatures and governors and presidents to help us with that. But we don't have an exemption from living in a society that disagrees with us. That's an important point, I think. Okay, so let's shift and talk about religious liberty protections under the First Amendment. Now, in Europe, their religious freedom protections are actually listed in documents that are quite lengthy. Their version of their constitution, the European Charter of Human Rights, for example, has a European Convention on Human Rights, has a fairly lengthy description of what religious freedom entails. Ours is very short. This is the very first part of the First Amendment to the United States Constitution. And it says very simply, you can read it here, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Now, what exactly does that mean? That's not many words for an entire charter of religious freedom. In fact, it's just a handful of words. Typically, the first part of that, the part that has the word establishment in it, is referred to as the Establishment Clause. And it basically means the government can't establish an official religion. We can't have a national church that everybody has to belong to, nor can the federal government create the equivalent of the Church of England, for example. Government can't force us to belong to a church. Okay, that's that more or less. And it can't force us to believe in a particular religion. And it can't impose a religious doctrine upon us. That's basically what that first piece of the First Amendment is addressing. Now, there are lots and lots of cases that deal with this and what exactly that means. This gets into school prayer issues and lots of things like that we won't have time to go over. But that's the Establishment Clause of the religion clauses of the First Amendment. The second piece of it, that or prohibiting the free exercise thereof, is referred to as the Free Exercise Clause. And that's where we often look for protections for the free exercise of religion. In truth, however, both of them work together. They are both created, they were both written into our Constitution by our Founding Fathers to protect the freedom of religion. So they're both vitally, vitally important. But who decides what they mean? There's all kinds of controversies about that. Who decides? Well, as a practical reality, the religion clauses of the First Amendment, those two clauses I just went over, mean what the Supreme Court says they mean. The Supreme Court in our constitutional system is tasked with the ultimate authority to interpret, to define, to tell us what the Constitution means. And so the role of the Supreme Court is absolutely vital when we're talking about religious freedom. Now, it's not the only thing that's vital. There are, of course, the laws that are enacted, the ordinary statutes are extremely important. What mayors and city councils and governors and regulatory officials and Congress itself does, all very, very important. But when it's all said and done, the interpretation of those critical words in the First Amendment to the United States Constitution, they are determined. The meaning of those words is determined by the United States Supreme Court. So, what has the Supreme Court been saying about religious freedom? What has it been doing with this vitally important language that pertains to religious liberty? So I want to talk a little bit about Supreme Court cases. And every Supreme Court case has a story of some sort behind it. And Supreme Court cases are driven by real people and real conflicts. Now I want to focus a little bit on the word conflicts here. This is an important point to understand. Rights are often in conflict. This is nothing new. You think about, free speech rights and your right not to be defamed, to have people tell lies about you that harm your reputation, your business. That's a conflict. The ability to say whatever you want and the right not to have your reputation destroyed by a falsehood. That's a little bit of a conflict. There are plenty of conflicts. The right to petition the government, as it says in the First Amendment, for a redress of grievances, that's the language in the First Amendment, is not a right to engage in riotous behavior, for example. Well, what exactly is riotous behavior? Well, there's a tension there. There's a conflict there. We fight about rights all the time in the United States. In fact, we've been doing this from the very beginning. What does the First Amendment mean? What does the Second Amendment mean? The right to keep and bear arms. What exactly does that mean? What does it mean to be free, as the Fourth Amendment says, from unreasonable searches and seizures? What does it mean to not have your property taken from you, as the Fifth Amendment says, without due process of law or without just compensation from the government? What does that mean? What does it mean to have a right to a jury trial? In what context does that apply? Where does it perhaps not apply? What does it mean to be free from cruel and unusual punishments? These are all things, and many other things, that are in the Bill of Rights. And so we have been fighting over those kind of things for many, many years. What exactly do these rights mean? I say this because it's important not to get disturbed and to be overly concerned when there are situations that arise where religious freedom rights are in conflict with some other right. And it's important to pay attention to those things. It's important that we get the balance right. It's important that we get the mix between a robust religious freedom right and some other right that might exist. And so this is the hard work of courts and legislatures and executive officials and ultimately we the people. But every Supreme Court case has a story, and usually the story involves a conflict. This is a picture of a Native American smoking peyote. Peyote is a hallucinogenic drug that has been used for many, many, many decades, maybe centuries, in Native American religious rituals. It is used sincerely. It is used as part of their core exercise of religion. That brought us to a case called Employment Division against Smith. Now, the facts here were that 2 Native Americans were fired by a private drug rehabilitation group because they used peyote as part of their religious worship within the Native American church. So they worked for a drug rehabilitation group, and they were terminated for using a drug, peyote, that was illegal, but they were using it in the context of their religious exercise. Well, after they were terminated, they applied for unemployment compensation benefits. And the state of Oregon said, no, you don't get to have unemployment compensation benefits because under our state law, if you are fired for work-related misconduct, then you can't get unemployment compensation benefits. And work-related misconduct included using illegal drugs. And so the question that went up to the Supreme Court to resolve was, does the First Amendment prevent the state of Oregon from denying unemployment benefits to those fired for using an illegal drug during religious worship? What do you think? Well, the court ruled no. You don't have a right under the First Amendment to use an illegal drug and then to get unemployment compensation benefits if you get fired from your job for using that illegal drug. This was a really important decision. The facts of it were fairly narrow and didn't apply to that many people, but the implications were very broad because the Supreme Court said something that it had not said in a very, very long time. It basically said that there is no religious freedom protection from laws that don't target religion and that apply to everyone equally. Okay? The language the court used was neutral laws of general applicability. So basically, if a rule applies to everyone, you don't get a special get-out-of-jail-free card just because you broke the rule in the name of your religion. Now, on one level, that seems to make a lot of sense. But imagine you're a Catholic, and you go to Catholic Mass, and at Catholic Mass, there is the ritual of the Eucharist, and they have wine that they consume during the Catholic Mass. Imagine a law that said that alcohol is completely illegal with no exceptions. What would happen to the Catholics under this kind of a rule that as long as it applies equally to everyone, it's not a problem? What if you had a law that said that no one could ever gather together, and that would include the ability to go to church? Is that the end of the story? That it applies to everyone? So that was a challenging decision. Some may argue that the outcome was just fine. The government had a really important interest in stopping drug abuse. But the rule that the court used was really troubling. Well, it wasn't long before another case came along that involved another religion we don't hear too much about, the Santeria religion. Now, the Santeria religion, I don't know too much about it, but it's kind of a mixture of African-type religions and with a little bit of, perhaps, a little bit of Christianity, maybe a little bit of Catholicism worked in there. Don't hold me to that. I'm not an expert in this religion. But what I do know about this religion, as this picture indicates, is that they practice chicken sacrifice as part of their religion. And this is actually a photo you have in front of you of the outcome of a sacrificial ritual using chickens. This sparked a controversy. The church is called the Church of the Lukumi Babaluai, and the church got in conflict with a city in Florida called the city of Hialeah. This was back in 1993. And the facts of the case were these. So the Santeria Church, as I mentioned, practices animal sacrifice in its religious worship services. The city of Hialeah didn't want animal sacrifices to be going on within their jurisdiction. It wasn't something they're familiar with. It wasn't something they were sympathetic with. And so they passed an ordinance, a number of ordinances, prohibiting the ritual slaughter of animals within city boundaries. Okay? So no one can kill animals for religious rituals. But then they went on to allow all kinds of other sorts of animal killings. You could hunt animals. You could butcher animals for food. You could kill a small number of pigs or cattle. So there were all of these exceptions. And in the end, what the court faced was a situation where a law was basically targeting one religion and prevent just that one religion from operating. Well, that went up to the Supreme Court. It was challenged as a violation of the First Amendment and the freedom of religion. And the court held that because the law targeted religion. It was shooting at religion, essentially, not literally with a gun, but it was attacking religion. The court struck down the law and said you can't do that. You can't target religion for special disabilities when you allow the very same kind of conduct, the killing of animals, to occur in lots of other circumstances. So that was an important case. Can't target religion. Now we'll fast forward a little bit to 2018, and this is a story many of you have heard about. This is Jack Phillips. Jack Phillips is a cake baker, and he resides in Colorado. He is a deeply Christian man, and he doesn't bake cakes for events that he believes violate his religion. So for example, he doesn't bake cakes for Halloween. He believes Halloween is of the devil, and so he won't bake cakes that celebrate Halloween. He also won't bake cakes that celebrate marriages that he doesn't believe in, that he doesn't believe the Bible countenances, including same-sex marriages. And that triggered the conflict. And this went to the United States Supreme Court. It's called Masterpiece Cake Shop. That was Jack Phillips' shop against the Colorado Civil Rights Commission. So here are the facts. Jack Phillips refused to bake a cake for a same-sex marriage. The same-sex couple brought a complaint under state anti-discrimination law and won at the state level, and the case went to the United States Supreme Court. In a 7-2 decision, the court ruled in favor of Jack Phillips, and it said that the Civil Rights Commission, the state essentially, had not been neutral toward the baker. It said that the commission had acted with hostility towards the baker's religion. It had made disparaging comments about his view of Christianity, his Christian religion. It had criticized him for his religion. And the commission had let other bakers refuse to make cakes with messages that they didn't like. So the rule wasn't applied equally. What the court said was that this indicated that this was an effort not just to enforce the civil rights laws, but an effort to target someone because of religion. So there's that targeting idea that we saw in the chicken sacrifice case, that came back. Well, that left a really important question. What would happen if they hadn't have said negative things about Jack Phillips and his religion? What would have happened if they had applied their rule, and their rule is that you cannot deny a service to someone based on sexual orientation. So you can't deny a service to a gay couple. That's the rule in Colorado. What if they had enforced that rule across the board? What if they had not tried to target his religion, or what if they had not made disparaging comments about his religion? What would have been the outcome then? Well, the Supreme Court didn't tell us. There was a lot of urging that the Supreme Court say, no, Jack Phillips, he has a right to bake his cakes for whomever he wishes, and if it's part of his religion that he doesn't bake cakes that celebrate same-sex marriages, he ought to be respected. The court didn't go there. Neither did the court say that it was part of his free speech rights, because a cake is expressive, and he ought to be able to control whatever message he puts into his cake and decide whether he wants to bake a cake with one message as opposed to another. The court didn't say that. The court just said, no, you were targeting him because of his religion, and we're going to leave these other questions for a later time. So that's an issue that's going to come up again. And in fact, there have been subsequent suits against Jack Phillips, and those are being worked out. This is Amy Stevens. Amy was born male, but now dresses and identifies as a female. She is what is referred to as transgender. Amy insisted on wearing a dress to the funeral home where she worked. She desired to present herself as a woman at work, and she was fired because of that. This is Gerald Bostock. He worked for one of our states as a child welfare advocate. And then the other picture is of Donald Zarda, who was a skydiving instructor. Both of these men are gay, and both of these men lost their jobs because they are gay. So this brings us to the issue, just like was at issue in the Jack Phillips case, of LGBT discrimination. Discrimination against lesbians, gays, bisexuals, and transgender persons. And this, of course, is a very hot topic. And as we saw in this prior case with Jack Phillips, the Supreme Court upheld his right not to bake a cake, only though because he was targeted for his religion. Lots of other questions to come, as I just mentioned. This was a case about whether our nation's employment discrimination laws, these laws that bar discrimination based, for example, on sex, so you can't fire someone because the person's a woman or a man, do those laws prohibit employers from discriminating on the basis of sexual orientation and gender identity? That was the big question in front of the court in the Bostock against Clayton County case. And this is a case that was just handed down earlier this year. A very hot topic, hotly disputed. Hotly disputed for a number of reasons, one of which was that this has potential significant implications for religious freedom and religious interests. What did the Supreme Court say? Well, in a 6-3 decision, this was a bit of a surprise for a lot of people because it drew two of the more conservative justices to the majority. So it was a 6-3 decision. The court ruled in favor of the employees. The court reasoned that discrimination based on sexual orientation or gender identity, in other words, discrimination against an LGBT person, necessarily involves discrimination based on sex, which is already illegal. And so the court held that our nation's employment discrimination law, which was passed back in 1964, where nobody was ever thinking about LGBT discrimination, that was never the thinking, that law nevertheless protects LGBT people from being fired from their jobs based on the fact that they are lesbian, gay, bisexual, or transgender. The gay rights community, of course, was elated. This was a huge victory for them, but it did raise some important religious freedom concerns. And the majority of the court actually addressed very briefly, because religious freedom concerns were not directly at issue, the majority addressed very briefly some of those concerns. And here's what the court said. It said, "We are also deeply concerned with preserving the promise of the free exercise of religion enshrined in our Constitution. That guarantee lies at the heart of our pluralistic society." So the court acknowledged that it is concerned with protecting religious freedom. And that's part of our society, a part of our nation, where people are allowed to believe what they want to believe. They're allowed to express themselves, and they're also allowed to do many other things. They're allowed to form organizations that reflect those beliefs. The court said it had plenty of legal tools to protect religious freedom in later cases where those issues would arise, but it didn't address those issues. So there is right now, despite these assurances, these very broad assurances, there is right now a significant amount of uncertainty as to what the United States Supreme Court is going to do when we have a situation, for example, of a church that has religious standards for its employees, and those standards require adherence to what we understand to be the law of chastity, that people cannot have sexual relations outside of a marriage between a man and a woman. Now that, of course, would adversely affect someone who identifies as gay or lesbian. And so how is that going to be worked out? Well, that remains to be seen. Important legal tools already exist in the law to allow a church to have its religious standards. Will those apply in the area of discrimination based on sexual orientation and gender identity? Well, that remains to be seen. Another case that was vitally important, that was handed down from the Supreme Court within the last, I guess it was at the end of June, so it hasn't been very long at all, is Our Lady of Guadalupe School against Morrissey Beru. I think I'm pronouncing that right. And the question there was, can school teachers at Catholic schools who have important religious duties, can they sue the schools for age or disability discrimination, or really for any kind of discrimination? Now, this gets into a question of ministers or people who perform very, very important religious functions within a religious organization like a religious school. Can the government force a religious school, can it force a church to employ someone who's really important to the religion against the will of the religious school or the church? That's a very important question because it relates to the ability of a religious school or of a church or of another religious organization to define its mission, to inculcate values, and to promote its message. Well, the Supreme Court, in a 7-2 decision, said that the school teachers could not sue the Catholic school. The Supreme Court ruled that because these teachers performed important religious functions at a religious institution, that they were like ministers. And the rule has long been you can fire your minister for any reason you like. So they have no ability to sue if you fire your minister. Well, the court said these women, these school teachers in a Catholic school, they had enough religious responsibilities and their work was important enough that they should be treated like ministers. And the court said courts cannot second-guess the hiring or firing of ministers by a religious organization. You probably didn't hear about this case, but this case is vitally important. It continues a series of cases that have upheld the ability of a religious organization to define who its religiously important people are and to employ people in religiously important positions who fully and completely support the mission of the church or the religious organization, the religious school, and so forth. Let's take a look at another case. This one came out of Montana, Espinoza against the Montana Department of Revenue. And this one also just barely came down. It's a 2020 case. The Supreme Court was very busy in 2020. The facts of this case relate to a scholarship program. So the Montana legislature passed a law creating student scholarships at private schools. And when parents tried to use the scholarships to send their children to religious schools, the Montana Supreme Court nullified the entire program because the state constitution had a little provision. Again, this is the state constitution, not the United States Constitution, but the Montana state constitution had what is referred to as a no aid provision, which basically says you can't give any aid to religious schools or to religion. And the state Supreme Court then struck down this whole program because it included religious schools. So parents could get this scholarship, which included government money, and could take the scholarship to a religious school and have their kids participate in the religious school. And under this Montana constitutional provision, that was technically unconstitutional. So the question was, does the First Amendment of the United States Constitution, and let me just pause here for a moment, the United States Constitution, as you know, is superior to state constitutions. So if there's a conflict between the two, the United States Constitution trumps the Constitution of a state. So the question was, does the First Amendment allow a state to bar parents from using tax-subsidized scholarships to send their children to private religious schools? Now, the court ruled on a 5-4 basis that the First Amendment did indeed bar Montana from denying access to the scholarship program solely because of the religious character of the schools. The court basically said that that is religious discrimination, that you can't, again, kind of this targeting idea that we talked about earlier at the beginning of these cases, you can't really target religion for a special disability, for a special prohibition based on the fact that it's religious. You can't do that. There may be other reasons, but you can't do it solely because of the religious character of the institution. And that would include solely because of the religious character of an individual, I would assume. So that is an important case. Chief Justice Roberts in this line that I thought was memorable, said this: "A state need not subsidize private education, but once a state decides to do so, it cannot disqualify some private schools solely because they are religious." So it's the idea you got to treat religion even-handedly. That's one of the very, very important protections. Okay, let's talk about the Little Sisters of the Poor. Some of you may be familiar with this wonderful Catholic order of nuns. It is entirely dedicated to serving the needy and the sick, and especially those who are at the end of their lives. And they have just a beautiful, beautiful ministry. Now, why on earth would they be involved in a lawsuit that goes all the way to the Supreme Court? Well, here's what happened. The Affordable Care Act, sometimes known as Obamacare, requires employers to provide contraception to their female employees. And the Obama administration, recognizing that some religious organizations have a concern with providing contraception, some of them believe it's just wrong. Some of them believe that some of those contraceptives cause abortion, and so they have deeply felt beliefs in that regard. And the Obama administration recognized that, and it created a religious exemption for some religious organizations, but not the Little Sisters of the Poor. And so they weren't included. Now, why it is the government would want to force an order of nuns to provide contraception, that's not clear. But in any event, that was the law. That was the rule. It was a special rule that was created by the Obama administration. Now, the nuns sued the federal government, challenging this administrative law. And the Supreme Court ordered the government to work out a compromise with the Little Sisters. And so that process of working out a compromise went on for some time. In the meantime, President Trump was elected to the presidency. And the Trump administration later issued a new rule exempting the nuns from having to provide contraception. That new rule, which the Trump administration had promulgated, which helped the Little Sisters, that was immediately challenged. And the question was, did the Trump administration, this was the question that went up to the United States Supreme Court in the case of Pennsylvania against Trump, really it was the Little Sisters. The question became, did the Trump administration properly exempt the Little Sisters from providing contraception in their health care plan? And the court said in a 7-2 decision that the answer was yes, that the Supreme Court upheld the Trump administration's exemption, said it was legal, but it did not hold that the exemption is required. So it said you could do it, but we're not going to say you have to do it. And so what is the result of that? Well, if there's a change in administration, if Joe Biden becomes the president, he might decide to change the rule back to the old Obama rule, in which case the Little Sisters would no longer be protected. So you could have this flip-flopping back and forth. For that reason, there were some who were in the 7-justice majority who wrote separately to say we shouldn't force the Little Sisters to have to go back to court again. We ought to hold that they are indeed protected. We ought to address that issue and just allow them to move on and not to have to worry about this anymore. But the majority didn't do that. They decided we're going to leave that issue for another day. So we'll see what happens in that regard. Okay, this is what social distancing in a church looks like. Some of you have gone back to church and you have to sit apart from each other, you have to wear masks, and it's all very careful. And this is what social distancing does not look like when you're talking about people at a casino in Las Vegas or just outside of a casino. And the interior of a casino often has lots of people milling around. Now, what do these two things have in common? Well, in the state of Nevada, the governor placed heavier restrictions on religious gatherings than on gatherings within a casino. And that was ultimately challenged. Let's look at the facts just a little bit. It was a directive or an order by Nevada's governor. It limits attendance at religious worship services to 50 people. Okay? But it allows casinos and other secular places to admit up to half a building's maximum capacity, which could conceivably be, hundreds, if not even 1,000 or more people. Well, Calvary Chapel challenged this, and they challenged the governor's order. And they did not succeed in the lower courts, and as a consequence, they sought an emergency application from the United States Supreme Court, and asking the court to force the governor to permit in-person worship services on the same terms, equal terms, as comparable secular assemblies like the casinos. So all they were asking for in this case was equality. Now this is interesting. You would think the Supreme Court would say, yeah, that's right. We've been holding for years, for decades, that you have to treat religion at least as well as you treat other interests. Well, the Supreme Court denied the emergency application. But it didn't issue any kind of an opinion, just denied it. So what on earth is going on here? Well, some of the more conservative justices filed very stern dissenting opinions. Justice Alito wrote, "The Constitution guarantees the free exercise of religion. It says nothing about the freedom to play craps or blackjack, to feed tokens into a slot machine, or to engage in any other game of chance." So Justice Alito was quite upset about this, as you could say, and other justices were very concerned. So what on earth happened? I mean, doesn't this violate the equality principle? Well, nobody knows exactly because the majority didn't write an opinion. But one theory, and I think this is probably right, is that the Chief Justice doesn't like emergency applications. These are rarely granted to begin with. Usually what happens is if you lose in the lower courts, you then appeal to a higher court, and then eventually you appeal to the United States Supreme Court. But you don't get to jump immediately to the Supreme Court. And this was kind of an effort to jump immediately to the Supreme Court. The Supreme Court doesn't allow that to happen except under very extraordinary circumstances. And it appears that the court didn't think that this was extraordinary enough. Or in other words, that the court was saying, let's let the lower courts do their jobs, and then they can come to the Supreme Court later if they need to get further relief. Now, some of you are familiar with Elder Bednar and his recent talk regarding religious freedom during the COVID crisis. And it was interesting because his talk pertains directly to this very situation. Now, he said, and this is very important that we not have any misunderstanding in this regard, Elder Bednar is not against, in his talk, he was not against regulations to prevent the spread of the coronavirus. He did not say that. In fact, he went out of his way to say, and I'll just quote this for you, "I am not for a moment saying that religious freedom can be unlimited in the middle of a pandemic, nor am I saying that all government officials have disregarded religious rights. Far from it." So he wasn't saying that. But then he goes on to say what he is talking about and what his concern was. "What I am saying is that we can no more disregard the valid claims of religious freedom in a time of crisis than we can disregard the valid claims of freedom of speech, freedom of the press, or freedom from unreasonable searches and seizures. Nor should we prioritize secular interests above religious ones. A health crisis should not become an excuse for a religious freedom crisis. I believe we must always remember a key principle. Specifically, religion should not be treated less favorably than analogous secular activities." Well, that appears to be what happened in Nevada, and that's a real concern. Very, very quickly, we got to conclude, but some upcoming Supreme Court cases. Fulton against Pennsylvania, the issue there. Did the city of Philadelphia violate the First Amendment by banning Catholic social services as a foster care provider because it does not place children with same-sex parents? Once again, these LGBT issues coming back. There's lots of conflict there. That's the current conflict In years to come, there are going to be other conflicts. In years past, there have been other conflicts, but that's a hot issue. The Supreme Court is going to hear that case, oral argument, sometime in October or November. I think it'll be in November, probably issue a decision in June or so of 2021. Another case that the Supreme Court has not taken yet, but might, does federal law, so this is the Dabristi case, does federal law require an employer to accommodate an employee's request for time off to observe the Sabbath or participate in another religiously significant event, even when doing so imposes some cost or inconvenience on the employer? In other words, can you get time off to go to church? And does federal law require your employer to give you time off to go to church, or at least to show that if it's not willing to do so, that it has a really, really good reason, that it's greatly burdened? Right now, unfortunately, the law is not very favorable to religious employees who want to get Sunday off, or in this case, it was a Saturday, to be able to worship together. Now, the overall picture, you know that Chief Justice Roberts is the Chief Justice of the United States, and I think this is an interesting little statistic. During the Roberts Court, so from the fall of 2005 until the present, that's been a long time, 15 years, religion has never directly lost at the Supreme Court. So this earlier case I talked about with the Nevada casinos, that wasn't actually a direct loss because there's no opinion, and that church can still litigate its way up to the Supreme Court. But during the time that Chief Justice Roberts has been the Chief Justice, religion has never directly lost at the Supreme Court. That is significant. Our institutions continue to take religious freedom seriously. Now, Elder Christofferson, what is it we're supposed to be doing as individuals? Elder Christofferson provides some comments here. He says, churches and people of faith must not allow themselves to be intimidated and silenced. Your opinions count. You have a right to speak and to be heard. Make the effort to stay informed about issues of public importance and then speak out with courage and civility. And I do emphasize civility. Our society needs your voice, your experience, and your goodness. That is just vital, brothers and sisters, that we not remain silent, that we get educated, we get informed, and we stand in defense of religious freedom. Religious freedom always needs defending. Why? Because religion at one point in time or another will always be unpopular with someone. Sooner or later, government is going to have an issue with what someone is doing religiously, with what a church is doing, with what a synagogue is doing, and so forth. And so it is vitally important that we get informed and that we stay vigilant. Now, we're in a situation right now in society where a lot of people don't think very highly of religion. And when people don't think highly of religion, then support for religious liberty goes down. That makes sense. We like to protect things that we like, and we don't like to protect things that we dislike. And so it has become more important than ever that we show the goodness of our faith. That has become absolutely essential to the preservation of religious freedom. Elder D. Todd Christofferson made this point as a final quote. He said this, "Finally and above all, as the Apostle Paul wrote, be an example of the believers in word and conversation, in charity and spirit, in faith, in purity. Live your faith so that others will see your good works, experience your genuine love and friendship, and feel God working through you. Americans tend to respect and protect what they believe is good. So let us show them the highest and best in our faiths, our willingness to love and serve others, to build strong families, to live honorable lives, to be good citizens. As our fellow citizens see the goodness of your faith, they will want to listen to you and understand when you say your religious freedom is being abridged. They may not agree with you or even understand entirely the issue that is so important to you. But if they know you and respect you because you are a true example of the believers, they will be far more inclined to work toward a solution that respects essential religious freedoms. Brothers and sisters, may we be true disciples of the Lord Jesus Christ, and in doing so, be true defenders of religious freedom. As they see our good works, even those who don't understand us or believe in our faith or why it's so important to us, they will nevertheless desire to listen and to understand. And as we do so, we will be defending religious freedom. That is my prayer and my hope. In the name of Jesus Christ, amen.